And the clerk, please.
Please be seated. Good morning. This is S-1-SC-39690, Sanders versus New Mexico Corrections Department et al. Can I have entries of appearance, please?
Yes, Sarah Shore,
Your Honor, I'm Adam Flores on behalf of the respondent, and I'm here with Laura Ives.
Right, thank you. Ms. Shore, you've divided your time 25 minutes and 5 minutes. All right, you can take the podium.
Chief Justice Bacon, and may it please the court. Question in this case is not whether the death of Catherine Paquin was tragic. It was. The question is also not whether we want agencies such as the Corrections Department to exercise care. We do. The question is whether the legislature waives sovereign immunity for the negligence asserted by plaintiff herself in this case. Specifically, whether the waiver of government immunity for negligence in the operation or maintenance of any building applies. It does not, for two reasons. Plaintiff claims injuries arising from defendant's alleged failure to ensure that inmate Christopher Blattner served the full term of his sentence. But such conduct is not operation or maintenance of the prison building. It is operation of the corrections department, conduct that under Archibek does not fall within the waiver.
Did Judge Huling address Archibek below?
She did not, Your Honor.
And really the tenor of her decision was related to geography, correct?
Yes, although I would add that her decision included a lengthy discussion of the premises liability cases that the court has issued, including Insidious, stating that there is no waiver under Section 4146 without a dangerous condition on a premises operated or maintained by the government. And the fact is that no government-operated property was rendered dangerous by Blattner's release in this case.
How is this not, how do we avoid equating what happened with your client to just a hole in the wall in a prison and somebody walking out that hole in the wall?
The way Justice Ransom put the issue in his concurrence in Archibek is helpful. He said that the risk of harm in this case arose from the classification decision itself, not from any condition on the premises. And that is precisely the issue here. The risk of harm arose from the determination that Blattner had served the term of his sentence, and not from any condition on the premises of a prison facility. Indeed, the name of the prison facility from which he was released is not even included in the complaint, which is telling.
In that case, in that special occurrence, Ransom indicated that if the plaintiff simply sought the wrong relief, the plaintiff wanted to be separated, administrative segregation, for his own protection. So that's just classification. But they'd asked for the dangerous person to be separated from the prison, put into lockup, and that might have been just this premises liability.
Yes, and that makes sense, Your Honor, because if there is a danger posed to all of the inmates in the prison by a condition on the premises, then you may have conduct under the waiver as held in Insidious. But in this case, the risk of harm did not arise from any condition of the premises. And by refusing to apply Archibek and misinterpreting Insidious, the Court of Appeals majority swept virtually any negligent government decision into the waiver for operation and maintenance of a building. The Court of Appeals interpretation causes the exception to swallow the rule of governmental immunity in tort, contrary to the express purpose of the Tort Claims Act. The Tort Claims Act establishes statutory sovereign immunity, which this court respects as the policy judgment of the legislature, the voice of the people. Its structure arises from the legislature's recognition that while the application of strict sovereign immunity has unjust results, the government, unlike private parties, has an almost unlimited ability to take on duties for the public good, and so should not have the duty to do everything that might be done.
How should the court interpret operation? Keeping in mind that the word operation occurs in all of the waivers, so it all has to, hang together.
Indeed.
And then also, how does Archibek survive any rational definition of our operations?
The court, for instance, in Espinoza, has interpreted operation in light of the purpose of this specific statutory waiver, which, as the court said in Archibek, is to keep the physical premises operated and maintained by the government safe for public use. And the reason that Archibek survives that sort of definition is because no physical premises was rendered dangerous by Archibek's release.
Isn't there a difference between an individual being released and a group of people or a generalized threat? So in other words, the difference, Archibek has to do with one person and not a group of people or an expansion of a threat. So in other words, not just one individual or one mob, but something different.
As an initial matter, the waiver, of course, refers to operation and maintenance of property, not to the scope of alleged negligence. And the impact on a single individual versus multiple individuals, that analysis has always come in the context of a premises where an individual has been injured by alleged negligence. And the question is, did the negligence pose a risk of harm on government premises to all the users, all of the students in Upton, all of the prisoners in Callaway, or only to the claimed plaintiff? Because if it posed a broader risk, then it can be fairly called a dangerous condition on a premises operated by the government within the waiver.
What about the
But-
case of both State Fair? There was no danger to the people on the premises. The danger was the negligence committed on the premises, but the effect was off premises.
I would disagree with you slightly, Justice Lawson, in that I think that the dangerous condition was uncontrolled traffic, which was emerging from the premises, but it was a dangerous condition on the premises itself as well. It injured someone immediately adjacent to the premises on a public road right next to the fairgrounds. But in this case, I want to emphasize,
What if the decedent here had been murdered 1 foot outside the front door? I mean, wouldn't we be looking at Bober as equivocal in some way?
I don't think so, Your Honor, because the nature of the decision is not one pertaining to the premises. It's pertaining to whether or not this inmate should still be in government custody.
What is the particular function of prison? It's to keep people in until they complete their sentence. I think in its primacy, that is its purpose.
I agree, Your Honor, but in this case, the negligence alleged is negligence in computing the terms of this inmate sentence, in accounting for subsequent sentences, in record keeping, in auditing of his inmate file. The defendants are the bureau chief of records and the secretary. This is not about a condition custodially on the premises of the prison. And the property has to matter because the waiver lists things that are physical property. It lists buildings, public parks, machinery, equipment, and furnishings.
That was dealt with in Upton, correct? I mean, that was dealt with in Upton. I mean, that had a similar nexus to the facility as this case does.
I disagree, Your Honor, in the sense that the operations of the school posed a danger to the students that were using the physical premises. There is no such danger posed to anyone using these physical premises of the prison.
So let me ask you about that and the question the chief asked about occurring right off the premises. And it seemed the dissent was focusing on this. And it appears to me they're sort of injecting foreseeability into this, into the reasoning, which I don't understand. So can you tell me, do you read it that way? Does foreseeability have any part of this analysis? Seems to me that dissent is saying, I'm not sure it's foreseeable. And quite frankly, I don't know if it's foreseeable what occurred. But that's not the analysis we're looking at under the waiver. Can you address that?
I agree that the dissent is inartful to the extent that it suggests that this is a foreseeability question. But it is correct in the sense that it observes that there is no dangerous physical premises that is connected to the negligence or the effect of the negligence alleged in this case. That aspect of it is correct. And it is significant, Your Honor, that because the general rule is immunity, this court has repeatedly held that only if a tort duty fits within one of the statutory exceptions is immunity waived. Waiver may not be implied, and the court does not read into the waiver's language which is not there. As I've stated, the purpose of the so-called building waiver is to keep property operated and maintained by the government safe for public use.
But haven't we gone a long ways from that? We're no longer talking about a defect in the physical premises. The precedent for the last 35 years has discovered that ever since ransom steel. So why do you keep arguing that?
There's a distinction, Your Honor, between a technical reading of the statute that applies it only to maintenance of the physical aspects of the premises. There's a difference between that and a total disconnection from negligence that actually arises and is connected to a physical premises. I agree with you. Upton, for instance, deals with negligent school safety practices impacting all of the students.
That didn't have anything to do with the brick and mortar of the
Yes, but it had to do with operation of a school, which is in a physical place. It's in a building, and it cannot possibly be the
The
case.
negligence here happened within the brick and mortar of a prison whose primary purpose is to keep prisoners in until they complete their sentence. So the negligence is happening within the building, much like it was in Upton.
But Your Honor, as Justice Ransom observed, the choice, the decision to release inmate Christopher Blattner did not change the condition of the prison facility. It did not cause a dangerous condition on the premises of the prison. And that is critical because if any government decision made in a building comes within this waiver, then all government negligence alleged to affect
So
more than one person is waived.
Hotspot parking lot off premises at a school. What do we do with that under the test, under the evaluation that you're presenting this morning? Is that a case that should be overturned, cabined in some way?
No, Your Honor, because that area was operated by the school. It was cordoned off by the school. It was set aside for the student lunch hour. There was a clear determination that the school had control over that area, which was connected to, immediately adjacent to the school and used by students.
Isn't one of the prison's responsibilities to secure the inmates and protect the inmates? In so doing, protect the public, keep the bad guys in, the good people out. Isn't that essentially what a prison is? And didn't you breach that responsibility in this case, arguably, if the case is proven?
First of all, Your Honor, any government decision could be alleged to pose a public safety risk, and any number of government decisions could be cast that way. But this waiver of immunity refers to negligence in the operation and maintenance of a building, of physical property. And Archibald tells us that operation of an agency rather than a physical property does not come within this waiver. And respecting the limitations of the waivers is critical to upholding the legislative purpose.
What if we were to overturn Archibald? Because Archibald, it seems to me, has created a lot of confusion and, in a sense, false expectations by attorneys and the public, and definitely by state government. What does this mean? Supervise, administration, that kind of thing. I mean, in effect, prison, every day is a day of supervision. You're supervising these inmates. You could insulate almost anything from responsibility.
Well, of course, I don't think the court should overturn Archibald because I think it draws important lines that are consistent with the lines the legislature drew. But even if the court overruled the Archibald majority, the holding, the concurrence makes an important observation that isn't contingent on classifications like custody or security. Justice Ransom says, the risk of harm in this case did not arise from a condition on the property. It arose from a classification decision, from a decision about operation of an agency. And similarly, in Insidious, this court held that there is no waiver under Section 4146 without a dangerous condition on a physical premises owned and operated by the government. And that precludes a finding of waiver in this case as well.
It seems, go ahead.
So what I understand you to say is that we should look not just to the geographical limitation that seemed to be the focus below, but to this discrete administrative function in Archibald. But I didn't see in the record a development of facts that this court could apply to follow that discrete administrative function analysis. Did I miss something, or would you agree that the record doesn't have factual content that would flesh out that Archibald wrong?
No, I disagree with that, Your Honor. The basis of defendant's motion for summary judgment was the Archibald argument. Our undisputed material facts set forth the duties at issue that were alleged to be breached, the people who performed them, and actually plaintiff's response didn't dispute any of those facts. It added purported additional undisputed facts, all of which simply confirmed that the conduct at issue was record keeping, a correct interpretation of this inmate sentence, auditing of the inmate file. Nothing about the response changed the undisputed facts that were in the motion and don't affect Archibek's holding as applied here.
Administratively, does the Department of Corrections have the authority to release an inmate that is not eligible for release?
I suppose I'm a bit confused by the question because the Corrections Department, of course, determines that an inmate is eligible for release.
If they are not eligible for release,
Not in fact, and the,
in fact, but they release them, do they have the administrative authority to do that?
yes, although it depends on the specific facility and the individuals involved. And in this case, that's, I'm pausing because that issue wasn't raised. The issue that was raised was the determination
And I
of the
don't-
duration of the
I don't mean to
sentence.
be tricky about it. Here's what I see the comfort in Archibek is if there's administrative decision on classification, you don't want to hold DOC liable for putting them in the wrong classification, right? They have that administrative authority.
Yes,
But that is different from what appears here, which is a arguably negligent act in releasing someone that isn't qualified. So, do you see any distinction between a discretionary act on DOC in classifying a prisoner and releasing a prisoner that, at least from the record, isn't eligible to be released? And I didn't know they could do that. I didn't, I never understood DOC to have the authority. If that inmate is not to be released, just to release them, that's not an administrative function.
well, Your Honor, first of all, I would note that it is true that the Tort Claims Act abolished previous distinctions between discretionary functions, ministerial functions, all of these things. The core issue is that this is about operation of a government agency. And the negligence alleged is in the determination whether this inmate was eligible for release. It's not the manner in which he was released. That is the negligence alleged, that his file was not audited properly, that certain databases were not checked. The negligence alleged is in that decision-making.
Let's take that a little further. Let's say that, that the plaintiffs can prove what I understand they're alleging, that this is not the first time this happened, that there was a chronic negligence in the prison, releasing people early. And these are dangerous people. Otherwise, for the most part, they wouldn't be in the prison. So you establish a pattern, you establish a risk to the public generally, Albuquerque, anywhere. Is there no scenario on which you argued that the prison could be held responsible for that, for creating this danger to the public?
No, I don't think there is a scenario under this waiver. No,
Let me
because
ask you a related question. If this were a private facility, which is really hypothetical, how could it be private? But let's say it was. And so the Tort Claims Act didn't even apply. Strictly a premises liability case. Would the defendant be liable for creating essentially a toxic hazard in the outside world?
well, I think that under your predicates, that's a tricky question to answer. Of course, we disagree that the scope of conduct encompassed in this waiver is simply everything encompassed within premises liability. And in our reply, of course, we took issue with the statement that, well, even if this waiver encompasses any conduct for which private parties, private property owners could be held liable, that the government in this case is not doing something that private property owners do. It's operating the corrections department. So, and I find those two distinctions to be critical. And if they went away, under ordinary principles of premises liability, I still disagree that you have a dangerous condition on any premises as a result of the conduct alleged in this
That's what
case.
you're hanging your argument on. The danger has to be on the premises, not off the premises, even though the danger is created on the premises.
And I don't think the danger is in any meaningful sense created on the premises. The decision was made in a building somewhere. As I said, the facility in which Blattner was held is not even named in the complaint for a reason. It's incidental. The negligence alleged in this case is in the administration of the corrections department. And the legislature did not waive immunity for that function. And I think the court respects that there may be good policy reasons that the legislature has not waived immunity.
But wouldn't the danger be created the moment that he leaves the building? I mean, that's when the danger is created, similar to when a whole bunch of cars are leaving. I mean, there is a danger that is being created that is leading off site, but that's where it's starting. That's the starting point. And if there's a danger created there, I mean, isn't there some sort of connection, nexus, if you have, that is where it happened, the moment he leaves the facility that's supposed to keep him inside.
That is not what this waiver encompasses. The waiver says that it encompasses negligent operation and maintenance of property. Any government decision could be alleged, if negligent, to create a public safety
But
risk.
again, I go back to one of my initial questions. How do we define operation in a way that is consistent for all pieces of the Tort Claims Act? It seems to me operation goes to the core function of whatever it is that's happening within that building. And if the core function is to detain people who have been convicted and sentenced, it doesn't matter if the decision was, the prisons in Santa Fe and the decision was made in Socorro. It's not about where the decision maker sits when they make the decision.
That's exactly the point, Your Honor. The statute refers to operation of physical property, not operation of an agency generally. Whatever operation is, it has to have a connection to the physical premises, the
It
function.
was not the operation of the physical premises. It was something other than that. It was policy decisions that were made that affected the overall operation of a school, but it had nothing to do necessarily with the premises.
Your Honor, I agree with you that a tricky aspect of the court's precedence on this issue is that some of them focus on the effect of the negligence. Is there a dangerous condition on the premises?
Boy, isn't that
others-
consistent with our law on negligence generally?
Yes. However, the waiver refers to conduct, operation and maintenance of the property. With a private property owner, we don't care if you were having a party, we don't care what you were doing. If there's a dangerous condition that arises on your property, a condition of unreasonable risk, you're responsible for it. With this waiver, it refers to the government's operation and maintenance of physical premises, of buildings, of public parks, of machinery, equipment, and furnishings. Whatever operation is, it has to be limited by a connection to physical property. And Archibald properly recognized that.
So what would the rule be to reverse the Court of Appeals, but save Upton? What would you suggest briefly is that ruling? Is it, to Justice Lawson's point, that it occurred off premises? What could you do to save Upton and support your position?
One holding would be that the Department of Corrections' negligent determination of an inmate's term of incarceration, including negligent record keeping, is not negligent operation or maintenance of a building within the meaning of Section 4146, but constitutes operation of a government agency, conduct for which 4146 does not waive Tort Claims Act immunity. And that saves Upton for precisely the reason that is in Justice Ransom's concurrence. In Upton, the risk of harm arose from a condition, a quality of the premises itself. In this case, there is no premises that has a dangerous condition. No premises is changed by the decision to release Blattner or any other inmate for that matter. Thank you.
Thank you, Your Honors, and may it please the court. In 2007, Christopher Blattner murdered a man while he was supposed to be in the defendant's custody. Blattner was then apprehended and sentenced for a series of unrelated crimes. And as a result of those sentences, he wasn't supposed to be released from prison until March of 2015 at the earliest. Instead, the Corrections Department erroneously released Blattner from the Guadalupe County Correctional Facility, a building 3 years too early. He was paroled to Albuquerque, where he absconded, killed Miss Paquin while he should have been behind bars. For Blattner to be released with a pending felony sentence, a number of corrections and private prison employees had to make a cascade of errors, falsify documents indicating that they had verified that Blattner was eligible for release. As it turns out, this wasn't an isolated incident. The early and improper release of prisoners, including prisoners from the Guadalupe County Correctional Facility, was a chronic problem at the department at the
So
time.
let me ask you the reverse. You go from Archibald to Callaway. If the court were to write an opinion affirming the Court of Appeals in this case, how would we save Archibald? And it goes to the point, which is a reasonable point and made by the dissent, that now this exception is swallowing the rule. Now there's really, for any discretionary act, there's no governmental immunity. We went from a defect in a facility to a Department of Corrections making a discretionary decision and now facing liability.
There are 2 points there. First, I disagree that the exception is swallowing the rule and that there's no governmental immunity. What I would say to that is that the waiver is more limited than this court has historically envisioned, and that would be consistent with ordinary tort principles of duty. The waiver is exactly what Chief Justice Bacon has been suggesting. It is related to whether or not a public employee, by its plain terms, is operating a building, either a public building or a private building within the government's control. And the test for that has never been squarely decided by the court. Instead, what has happened in the case law is that the court has sometimes taken breach of duty type arguments about whether or not a condition is sufficiently dangerous on a particular premises, and it has recharacterized that as the meaning of or as part of the definition of what it means to operate a building. You get a patchwork of precedents, from Espinosa against Town of Taos, where the court held that negligent supervision cannot be operation of a building. And then subsequent opinion from the Court of Appeals in Leahead against City of Santa Fe, where the court recognized that, well, negligent supervision, when you're talking about lifeguards in a swimming pool, can be operation of a building. And so what I would suggest is that in these cases, including in Archibald against Moya, what the courts have done, the Court of Appeals and this court, is imported negligence type arguments and considerations, including breach of duty, proximate cause, into the decision about whether or not a public employee is operating a building. And that, you can see it in the opinion in Archibald. You get a sort of bright line rule that the security, custody, and classification of inmates in a penitentiary isn't part of the operation of a building. That cannot be. If we're talking about a prison, that would be the same thing as saying that there's a prison exception in the Tort Claims Act.
And if Archibald were to come back and there's a head of a prison that makes a classification decision, a discretionary act, let's say it's on discipline, and makes what turns out to be the wrong decision, but a discretionary act, that person's liable, under your theory.
No, Your Honor, under
Why
my
not?
theory,
You're saying it's the operation of the building.
I'm not saying that that person is liable. I'm saying it is part
Well,
of the
the
operation.
waiver, that there's a waiver.
Yes, Your Honor.
So overrule Archibald.
The court doesn't have to overrule Archibald for this case to survive, because the court for years has never applied this rule that security, custody, and classification of inmates, it can't be a part of the operation of a building. I think it's helpful, Your Honor, if I can just trace the history of that a little bit.
The history I understand. I want to know what your rule is. You're saying the operation, any operation within the Department of Corrections, an act by a Department of Corrections officer, is the operation of a building. And if it is, there's tort claim waiver. Is that the rule?
Your Honor, I'm saying that conduct on public property or private property controlled by the government that poses a risk of physical harm, either to people on the premises or to the general public, is operation of a building. And that is, that's what this court in Insidious said that is to be.
Wasn't the danger here specific to Mrs. Hakeem as opposed to the general public? Because
No, Your
of their
Honor.
known relationship, much like Archibald.
The release of violent prisoners, somebody who's formally murdered somebody and whose file is supposed to be reviewed with due care. The release
Murdered,
of,
but not charged or convicted, correct? He was in for drug dealing.
he was sentenced for drug dealing. He had been charged with this murder, and then what happened was the state dismissed the charge temporarily, and this is all documented in his file so that they could prosecute an eyewitness first. And so he's since been convicted. So, yeah, the point I'm trying to make is that the entire public is put at risk by the negligent release of violent prisoners. And this is not the type of discrete administrative act that Archibald is talking about. This is part of a chronic pattern of negligent release at this particular facility in this building.
What if this is the act of a single person? I know that you are alleging that there's a pattern and practice problem here, but what if there was a single person who mistakenly signed off on Blattner's release? Notwithstanding what you want to prove, but just one person. Is that enough to give you what you want here, given that Upton really focused on this cascade of broader events?
Under the court's case law, the way the court has read Archibald, including in Upton, is that when a dangerous condition presents a risk to a broader segment of the population than the plaintiff alone, then immunity is waived. That would be operating a building under section 41.
So you would concede that if it was just one person making a decision about one inmate, we wouldn't be having the same conversation?
No, Your Honor, it depends on the specifics of that. If it was one person making a decision about one inmate that put a number of other a broader segment of the population at risk than that one inmate, then under the rule as it survived in Archibald, the claim could go forward.
Except under Upton, there was a real focus on this cascade of failures and multiple, like this bigger systemic problem. And that was, the underpinnings of the Upton opinion. So we're talking about one person making a decision, one person being released. I'm not sure you can equate that with what happened in Upton. And Upton is the significant departure from the path that the court had previously been on.
Your Honor, I can agree with that. I mean, if Upton is certainly about negligent security or negligent safety policies at a school or negligent implementation of safety policies at a school, under this set of facts, and this is part of the reason that we suggest sending this to the district court if there's going to be any consideration of the Archibald argument, and part of the reason why the Court of Appeals didn't abuse its discretion in declining to decide this argument. Under this set of facts, we can certainly show a chronic problem in the corrections department and at this facility, and a pattern or cascade of errors, as you've suggested.
And then to go back to, I think, the thread that Justice Thompson was trying to put together, if not Archibald, if say, we do harm to Archibald in this, in writing this opinion, what are our limiting principles? It's not administrative function. It's not geography or temporal limitations. And I get geography and temporal limitations to me are more of a foreseeability question. But what limiting principles do we have in place if we don't have Archibald? Is it just everything?
No, Your Honor, there are a number. First of all, it does have to be operation of a building. So just negligence out in the world, for example, under section 41412, claims against law enforcement officers for just pure negligence that don't result in an intentional tort aren't waived. That sort of negligent action out in the world by, say, a law enforcement officer wouldn't be operating a building. We are talking about, however this court wants to define operation of a building, we are talking about the core function, as you suggest, Your Honor, the core function of a prison, which is to hold people in custody. And Justice Thompson, that is not a discretionary act. The section 33-238 requires the corrections department to hold people in custody for the duration of their sentence. So there's no discretion there. This is a legislative command. That is what makes a prison a prison. And so I fully acknowledge that there's no clear case law about what it means to operate a building. My view is that Insidious has told us to look to the common law and that this is a premises liability statute. And so the same limitations that are available at common law for private landowners would be available here for the government. And there are duties. There are duties both to people on the land and people off the land at common law. This court in Tort Claims Act cases has cited to some of the duties to people off the land. And so here, for example, a possessor of land has a common law duty to those not on the land. A possessor of land engaging in conduct on the land must do so with reasonable care if it poses a risk of physical harm to persons or property not on the land. That would be, for example, somebody lighting cars on fire on their property, the toxic smoke, flowing off the property, somebody dumping poison in the river. There are problems if the court were to create an unequivocal rule that conflicted with those ordinary principles of premises liability. If the government operated a missile silo, for example, and the building operator whose job description is to operate this building negligently fired a missile, under the defendant's rule, if it happens to injure somebody off the land or sufficiently far away from the land, then there would be no claim.
But I don't want to disrupt your argument, but immunity is not a normal concept under premises liability either. I mean, this is a layover of immunity over basic concepts of premises liability. I mean, that's what we're dealing with is the scope of this statute that provides the government immunity, which it can do, and people can agree or disagree.
Right, Your Honor. There are two types. Oh, I'm sorry. Go ahead.
The appellant suggests we are departing, or would be departing from the legislative intent of the waiver statute. Do you have any response to that?
Yes, Your Honor. That is my entire argument, is that we are not departing from the legislative intent. The legislature tells us what its intent is in the declaration under section 4142B. So the legislature is navigating a balance about, it understands the government acts broadly and that it has limited resources. And so what it has done is it's reinstated governmental immunity, but limited that. And so, for example, there are lots of ways that the Tort Claims Act is protecting the public purse. It has a notice requirement that private parties don't have at common law before suit can be filed. It has a shorter statute of limitations. It provides a damages cap. It provides waivers that apply different rules for liability to different types of places and different categories of tortfeasors. It does not provide liability for intentional torts under section 4146. That limitation can be read right from the terms of the statute. It limits the types of damages that plaintiffs can recover. Under section 4146, personal injury damages aren't listed. So the legislature has told us these are the rules with this statute. These are the types of limitations that we have. This is how we're going to navigate this balance. But the minute that the government is making an argument that sounds anything like this condition wasn't dangerous enough to be operation, or this injury is too remote, well, then the legislature says that at that point, ordinary tort concepts of duty and the reasonably prudent person standard of care apply. And those ordinary tort concepts of duty, as Insidious has told us for this waiver for section 4146, are the premises liability limitations. And so just to trace the limitations for you to answer your question and the Chief Justice's question, there are limitations in the types of damages. There are limitations in the types of claims. The ultimate limitation is when a jury will consider proximate cause and breach. And the court, in a case where the government just shouldn't be liable, can always decide proximate cause and breach is a matter of law. But what I'm suggesting is that is what the court should do. The court should be upfront about that and say that in a particular case, there is no, as a matter of law, no reasonable jury can find that there was a sufficiently dangerous condition on the premises here, or no reasonable jury can find that these injuries were foreseeable. And
There's always a dangerous condition on the property when the property's a prison, right? So what we'd be talking here about, and I'm sort of applying those Gebler analysis, which seems like a helpful summation of all these cases. First prong would be, was there an operational failure to discover a condition on the property that could pose a danger? And would I be correct that there wouldn't be a failure to discover such a condition because there wasn't a condition of the property itself, right? It's an administrative failing. Am I correct with that?
no, Your Honor, this is part of why I was trying to go cover the facts a little bit and why this court should be remanded, or this case should be remanded so that the district court can consider those sorts of questions. There is, first of all, anything can really be characterized as an administrative act if we're talking about the government. And so I would be careful about any.
Well, the second prong is about a failure to put reason, safety conditions and the like. So I mean, the first prong seems to be in Gebler is about the property and the nature of the property itself. And the second part, and this would be the Upton piece and others, is were there appropriate policies or safety conditions to be put in place? And what I understand you to be saying is there's not a problem with, there's the inherent danger of a prison, but there's not a problem with the physical property per se. I understand you be saying that there wasn't reasonably appropriate safety conditions put in place. Is that?
Your Honor, I read Gebler a bit differently. What I think Gebler is saying is that it's similar to what Chief Justice Bacon was saying, that there are two sort of categories. When you distill the case law, there are two categories of cases. And there are some where you're talking about operational failures in a public building. So Gebler, for example, was a case about a negligent dispatch. You know, so if a dispatcher's, if in that case there was a complete operational failure in that public building about what the purpose of that building is, then there could be a waiver under Archibald. The second type, as you mentioned, is the Upton type waiver. So security or policy decisions, I suppose, or security, safety policy implementation. And in this case, we meet, if the court were to look at the facts, we meet both types of waiver under Gebler, at least as I read it. Again, if security, custody, and classification of inmates is not part of the operation of the prison, then I believe that would create a prison exception to the Tort Claims Act. And so I do just want to point out where that came from, because I was looking at it in Archibald, and what Archibald did is it cited to a prior case from the Court of Appeals. There's no explanation, there's no statutory construction, there's no analysis of how they came to that conclusion. What the court did in Archibald is it cited to a prior case from the Court of Appeals called Wachowski against State. And Wachowski is the first case that said that security, custody, classification decisions aren't part of the operation of a building. And Wachowski said that because at the time the court was reading the building waiver to only apply to physical defects on the land. And so if you look at Wachowski, it says the building waiver only applies to physical defects on the land. Security, custody, and classification decisions are not waived. And so, you know, that statement should be discarded if it hasn't already. I haven't seen this court or the Court of Appeals apply that sense. And in Callaway, which was less than a year later, dealt with a situation involving security, custody, and classification of inmates and allowed the claim to go forward. Your Honors, factually, I do just want to point out some of why I think the Court of Appeals should be affirmed in declining to decide this argument for the first time on appeal. And what happened in this case is that after Ms. Paquin was killed, the department did an audit of early release. And so my understanding is that the department actually looked at every inmate that was released between 2006 and 2013 and found that there were hundreds of other instances of early release and that this was a major problem at the time. And so in discovery below, we had asked for those materials, those audit materials, and they weren't actually produced. You know, we'd asked for them in November of 2014, and then there were some discovery disputes. And those materials weren't actually produced until after this summary judgment motion was fully briefed, after discovery, 4 months after the close of discovery and shortly before trial. And so what we did below is we asked for some limited relief. We asked for the ability to depose some key personnel about the information we were getting. And then we asked the district court to allow us to add this information and sort of supplement this information into the summary judgment briefing. And you can see in the district court's order, the very first paragraph under the facts and background section, the court denied that request. And the reason the court denied that request, according to the order, is because it didn't find that those facts would be relevant to the issue that it actually decided, which was this hard and fast rule about the location of an injury. And so
So are you saying there, I'm sorry, counsel, are you saying there that the district court didn't look to Callaway and didn't see the cumulative, didn't look to those issues and just relied on what?
well, Your Honor, so the department briefed Archibald, and the district court didn't decide anything that the department briefed. And so the district court wasn't looking at Archibald, it wasn't looking to Callaway. What the district court did is it said basically, you know, we've gone too far, that when an injury occurs far enough away from the land, there is no waiver of immunity.
So were you encouraging this court to not deal with Archibald?
Yes, Your Honor. That's at least to the extent that this court believes that Archibald involves any factual determination about whether there was a chronic problem or the nature of the public safety risk, then the court should remand or affirm the Court of Appeals, which properly exercises discretion not to consider this argument for the first time on appeal.
Okay, so that's helpful. So your request is different from where we started, in my view. So this is helpful to me. So you're suggesting we need to just address the limited question of whether the district court got it wrong in this concept that because this occurred off-site.
Yes, Your Honor. And then I'm also suggesting that the petitioner didn't really brief that issue. And so, you know, the petitioner has been trying to make this Archibald argument, and things went awry when the district court didn't decide the Archibald argument. And I suspect that the district court didn't decide the Archibald argument because it didn't want to deal with these 30,000 pages of late produced evidence. And so what the district court did is it made an unequivocal pronouncement about what waiver means. And that pronouncement, it just has no support in the statutory text. What the statutory limitation is whether or not a public employee is operating a building. That has nothing to do with where an injury occurs. You know, the case law, Ober against New Mexico State Fair, you have injuries off the land to a non-user of the building. In Sinius, you have an injury off the land. And in common law premises liability, you have injuries off the land. And so if the court takes what Insidious said seriously, then you know, all of these negligence type arguments are really breach and foreseeability arguments. They should be decided in accordance with ordinary negligence principles. The court should follow Rodriguez against Del Sol Shopping Center and permit courts to make these decisions, but they would have to do it by concluding that a reasonable jury can't find proximate cause or breach.
Supposing, see if you can answer this. As I understand your opposing counsel, she's making the argument that there was no dangerous condition created on the property. The danger was off the property. I guess that's true from what I understand of this particular case. Now, a lot of our precedents do concern danger that was really both on the property, off the property. In this case, I don't know if there's a danger to the people within the prison. I don't think we have enough information. But that's a bright line that I think opposing counsel is trying to make. To despite Boker, let's say. So how would you have us handle that?
The court should apply common law premises liability principles. At common law, there are lots of different duties that landowners have, but the two main categories of duties are duties that endanger the class of users who use the premises, and then duties that endanger the public outside of the land. And for example, one common law duty that is directly applicable to this case is that a person who's in a custodial relationship with another person who's known to be dangerous has a duty of reasonable care to the general public to prevent physical harm caused by the charge. And so what the restatement says is that the classic custodian under this section is the jailer of a dangerous criminal. So there is no question that there are applicable duties that would apply to private parties. And by the way, there are private prisons, there are private prisons in this case. And so the fact that an agency is actually operating a private prison because only the corrections department can release an inmate. It doesn't matter if the agency is off-site. We know that from Cobos against Doña Ana County Housing Authority. If the agency is operating a building, which is what the text of the statute says, then the building waiver applies. And I do understand, I take everyone's point that there could be, it seems like broad liability, but again, this liability is limited the same way that liability would be limited to a private landowner. In many of these cases, the case could be dismissed because there is no rational jury that could find proximate cause or breach.
I guess so with a private landowner, if they're engaging in an inherently dangerous activity on their property, which I would submit a prison that the state's running and needs to run could meet that description, then there's heightened levels of liability and the like that don't seem to be contemplated by this waiver. So how should we define the scope for a state, or this state, as to when it is liable for something that has to be dangerous, like a prison?
Well, the court doesn't have to do anything other than read the text of the statute. The statute says operating a building, and the statute, as this court rightly pointed out in Insidious, is incorporating common law principles of premises liability. And so the court should just look to whether or not a public employee, just according to the plain terms of the statute, whether or not a public employee can be said to be operating a building. And maybe Gebler is the appropriate test for that. I'm not sure what the test is, whether somebody's operating a building, but I can tell you that under this set of facts, a prison is being operated by public employees when it's releasing prisoners.
What if there's a parole board? What if the parole board release someone, parole, they go out and hurt somebody? And they made the decision in a building.
So, Your Honor, I guess that is a difficult question that's not at issue in this case. I don't know the answer to that. The court can decide whether agency conduct in some building amounts to operation. We're talking about opening the doors to a prison, opening the doors to the Guadalupe County Correctional Facility. And so I'm not trying to, make some vast expansion of Section 4146. I'm just pointing out that the real.
Doesn't that go to the issue of following a statute? So the statute says you can't release somebody under these until they've served their time. This is how you calculate it. You release somebody when they're not eligible for release. So the difference has to do with whether there is a law or a rule or some form of structure that is in place that you're supposed to follow that you don't. Isn't that the difference?
In this case, it's important because we're talking about a private prison. And so in this case, I'm in another case involving a public prison, even if that law wasn't on the books, I'd argue that the core function of a prison is to keep prisoners in prison. As we're talking about a private prison, the reason the government can't argue that they had nothing to do with this is because by statute, the government can't contract.
But that's, I think, what Judge Levy is saying is that's the distinction between this case and the parole board case, where the parole board has the authority to make the decision about when somebody's released. Whereas here, the individual did not have the authority.
That's true, Your Honor. Take your point, Your Honor. That is correct. Looks like I'm out of time and unless the court,
Goes fast.
we ask that you affirm the Court of Appeals and send the case back now.
Thank you.
I do want to address the respondent's characterization of Archibek as lacking reasoning because the Court of Appeals said this as well and it stated that we did not adequately brief it and that remand is appropriate for further development of the factual record. And we take issue with all of these things. And so I would like to emphasize that Archibek actually distinguishes subsequent case law, including Bober and Castillo, and emphasizes that there was no dangerous condition on the premises of the prison in the Archibek case. Furthermore, Archibek discusses the purposes of the act and actually states that the legislative purpose of Section 4146 is to ensure the general public safety by requiring public employees to exercise reasonable care in maintaining and operating the physical premises owned and operated by the government. And that in that case, the defendant was performing an administrative function associated with the operation of the correction system and not with the prison facility. And that is the case here. That has been our argument since the district court. It has been fully developed. We are entitled to have it considered. Plaintiffs did not file a Rule 56 affidavit. They had some 24 additional undisputed material facts. At the very end of their brief, they mentioned audit results with some 41 inmates whose sentences were allegedly inaccurately
Why
calculated.
should we consider this in its first iteration in the Supreme Court as opposed to the district court? Because Judge Schuling clearly did not follow you down this path. She landed on geography. Nothing more, nothing less. I mean, she did not go with you here. She said, it's too far off the premises. She didn't dig in to security, custody, and classification, which is the language of Archibek. And I really don't think it's our job to compare a limited factual record
But Your Honor, what I would,
in tackling the argument that you're making, because you want us to go with you and say, well, of course, this was nothing but administrative. Archibek is fine, nothing to see here. And I'm not sure that's what the record supports.
Your Honor, and what I was going to get to is that even if that additional information was true, it doesn't change anything under Archibek. The release of Blattner or 10 other inmates doesn't change the condition of the prison premises. And this court states that it will affirm as right for any reason as long as the right result was reached, even if it was for the wrong reason, and particularly if it's an issue of foundational importance, even if not well briefed. The court so held in ideal. And that is precisely the case here. We are entitled to have our Archibek argument addressed. None of the facts presented below, and plaintiffs did not, again, file a Rule 56 affidavit, but even if there were audit results showing additional inmates had their terms of incarceration erroneously calculated, that doesn't change anything. As Justice Ransom stated, the classification of Archibek did not change the condition of the premises. That is true here. The classification of Blattner or any other inmate did not change the condition of the premises. And Your Honor, I do want to emphasize that this court has repeatedly stated that it does not judicially abrogate the legislative imposition of sovereign immunity. And in this case, Archibek recognized the importance of respecting the lines drawn by the legislature in the waivers of immunity in the act, in which the legislature chose to make immunity the rule and waiver the exception.
There's nothing in the Tort Claims Act, is there, that exempts from claims acts committed by public officials in the nature of administration, supervision, classification. Nothing in the act says that, does it? It was only Justice Baca coming up with those words.
Your Honor, that is precisely the point. The areas in which the legislature reserved immunity and did not waive it are the areas in which no negligence claim can proceed. And so the legislature, the court must assume that the legislature explicitly intended not to waive immunity for the functions that you just listed. And for good reason. The legislature is the policymaking branch. It has a good deal more information, breadth and depth of information in front of it when making these decisions than in any given tort case. It can decide that executive agencies ought to be held accountable through majoritarian policymaking.
Change the facts again a little bit. Supposing in this case, this inmate was known to be a risk to the world. He was half crazy. He threatened to get the president, to kill the governor, to go to the mayor of Albuquerque and assassinate him or her. And therefore, it's the kind of person that was a real risk. Lots of evidence of that. And then he goes and kills somebody, some random person, just like he said he would. Even under those circumstances, you wouldn't allow this lawsuit, would you?
Assuming that all of the other facts are the same, that his...
Yeah, assuming that all the rest. Yeah.
That's correct, Your Honor.
And assuming, changing the facts again just slightly, the threat was to one person specifically. I'm going to get even with my ex-wife. I'm going to kill a rival gang member, that the guy, angry at him. And that's exactly what he does. And everybody knows that that risk is there. But it's only to that one person, not the general public. Same conclusion.
If the allegations are that his term of incarceration was incorrectly determined by the corrections
Yeah,
department,
wrongly
yes,
released, yeah.
because the waivers of immunity don't encompass all government negligence. They don't, intentionally.
Thank you.
Thank you.
Thank you for the presentations today, council. The case is being submitted as of today.